Right.
And so on and so forth.
Okay, and as you know, this is Adam Pedersen, and just give us a brief background on your bio and what you do here at our firm.
All right, so good morning, everybody. Thanks for joining us on the webinar today. Great to have you. Happy holidays, everybody. I've been practicing real estate law for about 10 years now, and with a focus in transactional work. I've got my broker's license as well as my license to practice law, so do transactional work as well as litigation over transactions gone wrong, concerning non-disclosure disputes, contract disputes, and the like. So really a little bit of everything. And as you know, as an office, we've sort of got the real estate law covered from the ground up, as we like to say.
Right. And my name is Ashley Gonzalez. I'm in my 4th year of practice here at the firm. I've been here since I started. I help clients buy and sell property, get out of a transaction, help save the transaction. I also do a lot of partition cases, easement disputes, landlord-tenant, pretty much everything. I think being a younger associate, I help on everything just so I can absorb as much knowledge as possible. And I've seen a lot of transactions go bad, and also I've seen a lot of them be saved just by doing these little nuances we'll tell you about, and we'll go through each one of those. So to get started, first we're going to do a contract overview. The most common forms used that we see in California are the CAR forms and the PRDS. For CAR, that's the California Association of Realtors, and for PRDS, it's the Peninsula Regional Data Service. And on our website, I gave a link in our slide here if you want to make a note for that. We actually have a really cool resource that one of our colleagues, Simon Offord, made with Clayton Dodds, our marketing director, where we talk about the differences between the PRDS form and the CAR form. And they are minor, but it is very important to know those. And depending on where you're buying or selling, the forms could really come in handy.
Right, and just as a practice example, the CAR form and the PRDS form, just as one example, handle contingencies, for example, very differently. So if you're completing the CAR form and you put, for example, a 0 in the spot for the length of the inspection contingency, some people might expect that would create at least the impression that the contract's not contingent on that, but that's not the way the language works in the CAR contract, which we'll get into in more detail a little bit later on.
Right.
But if you look at the PRDS contract, it specifically says that placing a 0 in there for the contingency period does remove that contingency. So a huge difference. It can have a big impact on the deal, whether you want to cancel the deal or save the deal, and it really doesn't require a lot of contract knowledge to suss those out. But yeah, the resource that Ashley has highlighted, which you have the link to, helps to tease out some of those differences for those who are interested in learning the differences between the two forms.
Right, and just I gave 2 examples of the differences that are on the tool that we have on our website. One of those is the as-is provision. The other is property taxes and HOA fees. For as-is, this is a huge term in transactions because in the CAR form, it's the default. You don't have to select anything to make it an as-is sale. And it's important for sellers to know this because when they're selling their property, they don't want to be obligated to make any repairs or do anything extra without an agreement. And for PRDS, this is optional. And so unless it's checkmarked by the agent or us, if we help you sell your home, it's not going to be the default, and it could really run the seller into some problems with being obligated to fix certain things before close of escrow. And then with property taxes and HOA fees, which can be substantial, especially with this area and home prices, and almost every property we see, I would say 90% of them are in the HOA. And so CAR gives the option to distribute those fees and costs. PRDS establishes who pays for that. So it's very important to just know those little nuances and the differences.
Right, especially, good point with respect to as-is transactions. I think for those real estate professionals who may be watching, the assumption I think of most of your seller clients is going to be that they're selling their property as is. And so if that isn't adequately addressed in the contract, that could be a problem.
Right. So next, we just want to talk about the contracts generally in respect to the law. And Adam will give a breakdown on one of the more important aspects of forming a contract in transactions.
Right. So one of the basic principles of contract law is what is referred to as the mirror image rule. And Ashley probably remembers that from law school. And if any of you out there went to law school, you'll probably remember that. And it's really fundamentally kind of a basic principle that only gets complicated in its implementation, which I guess you could say is true for much of the law. But the mirror image rule is, as it sounds, a rule that requires that if an offer is made, that the acceptance of that offer mirror the offer itself, that essentially no changes can be made in between the offer and the acceptance of that offer.
Right.
And in fact, if changes are made, it doesn't mean necessarily that there is no potential deal to be had, but generally the law will consider that acceptance not an effective acceptance of that contract, but a counteroffer. Right. Why is that critical? I think, those of you who have experienced this probably see where I'm going. It's that if I return to you what I believe to be a signed acceptance of an offer, thinking that we're in contract, but really the law says, no, that's a counteroffer, and it's got to be then accepted by the person who made the original offer, we don't have a deal. We may have a deal, and that may be acceptable, but we don't have an enforceable contract at that point.
Right.
So it's very important that match up. And so we have here on the slide some common, areas where there's a disconnect, but just in practice, one of the things that I'm sorry about that. One of the things that I've noticed is that the CAR form has a couple provisions that need to be initialed. Specifically, I'm referring to the arbitration provision, and I'm also referring to the liquidated damages provision. Quite often, either intentionally or unintentionally, the offer won't have those boxes initialed. But then they will be initialed by the seller who receives the offer, then reviews it, and as a matter of course, initials those boxes. Well, because they're not uniformly completed, what the seller has done is effectively make a counteroffer, including the arbitration clause or the liquidated damages clause, or both, and then it's up to the buyer to accept those or deny those. So there's really not been a contract formed at that point, even though the parties may think they have a contract. And what happens is that party may then want to get out of the contract later on, or change the contract later on, ask for repairs, and they give it to somebody like me who knows the contract, and I see that, and I'm going to use that as leverage to say, look, we don't have a deal here, and so we can then use that leverage to make changes or even back out of the deal potentially. And there's some nuances with that, with counteroffers and addendums. Did you want to go ahead and address that?
Yeah, before we get to that, I want to talk about one thing I've seen that has come up pretty frequently is buyers make an offer and the sellers return the purchase contract and certain items are crossed out.
Right.
And this could be a real sly way to counter where the buyer might not notice. They're going to look at the initial sections, the signature sections, and think everything is okay, but it's very important to review the entire contract when you get it back, because if they cross something out, a contingency or something along those lines that changes a substantial part of the contract, you can have another counter there and you could very well not be in contract. So I think not only adding terms or changing terms, but crossing things out in the contract, making notes, that all can be considered a counter, and I think you've seen that as well. Yeah,
and absolutely, and you raise a good point, and also to refer back to something that you were discussing previously, we talked about allocation of taxes, allocation of certain fees, escrow fees. Something as simple as buyer makes an offer with a certain allocation of escrow fees, for example, and then seller responds with a different allocation. That is, not a contract at that point, arguably. And because there's been a change, and the buyer then has to accept that. So that's a very good point. It's not just the initial provisions; it's also some of the more what people might consider minor details need to be looked at as well.
Right. So while we're on counter offers, let's break that down a little bit. And Adam's gonna. Do you have anything else to add on nullifying non-initial clauses?
Yeah, this is interesting. Actually, came up in practice for me recently. I had. A seller come to me, or actually it was a buyer, come to me about the enforceability of a contract. And the question was the contract enforceable? And there was some question about whether or not the liquidated damages and arbitration provisions were countersigned. However, the parties had later signed at least CAR counteroffers and addenda, and what that led to was the fact that, in fact, they did have an enforceable agreement, and this is because, quite simply, the language that the CAR forms contain. If you look carefully at those CAR buyer and seller counteroffer forms, they do two things. They integrate the original purchase agreement, and they expressly state that any provisions which need the buyer's and seller's initials, if they're not equally countersigned, are excised from the agreement, effectively removed from the agreement. So it sort of solves that problem, and it's designed to address that issue that we were raising before, where you don't have any counteroffers. You need to be careful. But when you do have counteroffers, those provisions essentially get taken out of the agreement if they're not countersigned. It's important to know for many reasons. Number one, so that your buyer or seller, when they sign that counteroffer, they know and understand that if those provisions aren't countersigned, that's not something they can rely upon later to say that there's no deal. Or if they wanted those terms to be in the agreement, it needs to be addressed in the addenda, because if not, they're just going to sign it, and then those provisions are going to go away, and they may not benefit from liquidated damages or arbitration because of the operation of those amendments.
Right, and that brings us to amendments and addenda. First, amendments, this isn't necessarily under the counteroffer realm, but it is important, I think, to have an understanding of. So once a contract's formed and something comes up, either the buyer needs more time or the seller is trying to get a tenant out or something along those lines, and the contract changes, or at least the parties' agreement changes, it's really important to execute an amendment in this instance. And I've seen a lot of cases where the parties had an agreement verbally or whatever the case may be, and they never fully execute an amendment, and that agreement is not enforceable. And also, if you're the party presenting the amendment, say if you want to extend close of escrow 2 weeks or however long, and the other side doesn't sign it, that amendment is not enforceable. It has to be signed by both parties, because you have to have a meeting of the minds to change the contract. And that could be substantial. I've seen disputes come up where, you know, the buyer didn't close in time, and he said, oh, well, I sent an amendment to change the close of escrow date. If the seller never signed it, then, you know, you're out of luck. So it's very important to make sure everyone signs that, and also to use the forms, because contracts, you know, they change. They're sort of like water. You can be formed to meet the needs of the parties, and don't be afraid to change the terms mid-transaction if that's what's going to help you close the deal. Also, addenda, I really like using them. I haven't drafted contract documents for a client without using any addendums, because there's always terms to the agreement that are outside of the purchase contract. For instance, things that are included in the sale that are in the home, personal property, paintings, chandeliers, that type of thing. You want to get every agreement the parties have memorialized in writing, and the addendum forms are super useful for this. The CAR made them, PRDS has them, so use them. If there's any, you know, compensation for repairs or deduction in the purchase price for any repairs that are contemplated, use an addendum. It's really just your way to customize the transaction. I think it makes it unambiguous of what the agreement is. Wouldn't you agree?
Yeah, I would agree. And, you know, you want to reduce it to writing. You want to put an addenda so it's clear. And you don't want to have, you know, scattered handwritten terms, you know, interspliced throughout the document. It creates ambiguity. It generates disputes. You know, so put it in the form of an addenda. As simple as it may sound, if you're going to change a paragraph of the contract, you know, identify that paragraph so people know what's being changed. You know, that way there's a clear record of what the parties' agreement was, and there's no dispute about it moving forward.
Right. I mean, for instance, we had a client that was selling a home in a historic area. You know, the property was classified as a historic property, and out of an abundance of caution, we made an addendum saying, you know, buyer beware, this property is located in a historic area. If you want to change or remodel the property, please look into the city code, or talk to someone from the city about that. And that's just another layer of protection for your client. And also, if you're the seller, to just make it super clear what the buyer is getting into. And we'll get into disclosures, but that's just another example that we've used that form. So next, we want to prevent fallouts ideally. You never want to see a transaction fold. And, we're going to go over some ways to prevent fallout, and we could break those up. Just first, I think a lot of people are afraid to negotiate. The market is so competitive nowadays, and everyone just wants to get their offer accepted. And once that happens, they're afraid to rock the boat. And I think it's just parties need to be aware that you can negotiate, and that's what's really going to save the deal. Is if one side is not satisfied during the transaction, communicate. Just tell the other side what you want, what you're thinking. And a lot of times people are going to, accommodate your request because they want the sale to go through. They want to move on from living there, or they want to complete the transaction to move on to the next property. And so it's really important to just open that line of communication and get a negotiation going.
Right, yeah, deals are most successful when the parties to the deal know and understand the terms and are getting what they want, or at least something close enough to what they want to be comfortable moving ahead. It's a very competitive market, even though the market has, for all intents and purposes, cooled off to a very slight degree in recent times. It's still very competitive, and so there's this rush to get into contract or put a property under contract, and it's not necessarily in anybody's interest to do that, because once people's heads kind of cool off after that competition to lock it down evaporates, and then they start looking more closely at the property and at the terms of the deal. Quite often buyers get cold feet, or sellers feel like they didn't get what they were looking for. And so it's just important to have that conversation up front and make sure that the contract is what everybody wants. I also think that it's important to be ready to proceed with the transaction when in contract. A lot of times people are very focused again on getting the deal inked so that they can feel like they've locked the property up, but they're not ready to move forward with what they need to do to feel comfortable making the purchase. A little bit outside of the scope maybe of this webinar, but a lot of offers are written non-contingent. We'll talk about the mechanics of contingencies, but the strategy of contingencies is generally that it makes the offer more competitive. However, what that does is it effectively limits the buyer's options after getting into contract. And so if anything comes up, the buyer is then incredibly skittish, for lack of a better word, because they feel like they've not been given the opportunity to have their own close personal look at the property. So while I understand sellers' motivations for pushing against those contingencies, on some level it could actually benefit the seller in the long run to allow some inspection contingency, even though that injects some risk the deal may not end up consummating, because at the end of that period you can all be assured that the buyer has had time to look at the property, review it, and feel comfortable moving forward. And bottom line is, even if you don't have contingencies in your deal as a seller, you probably don't want to force somebody to buy a property that they really don't want, because that's going to generate problems for everybody. You may very well be in the right, but that may not very well be the best option for you at the end of the day.
Right, and the header in the slide is plan ahead, and I think that can go for all of these things, but most importantly, have your vendors lined up if you're the buyer. Don't get in the contract and start looking for a mold inspector and an appraiser, those types of things. Make sure that they're ready to go, their schedule permits the inspection, because 14 days or however many days it is isn't very long. And some of these people, depending where the property is, you might want a structural inspection, you might want very unique things, and their schedule might be booked out 6 weeks, and a seller might not be willing to accommodate that. So you really want to have your vendors lined up, and then also do your own investigation even before you put an offer in. I mean, the internet is super powerful. You can look up the local ordinances. You can look up, a lot of times the disclosures are already uploaded, so you can do a thorough review before you even make an offer. And we'll talk about the mechanics of receiving the disclosures before you make an offer and what that means. But really just planning ahead will really prevent a lot of fallout.
Right.
Next, that brings us to disclosures. And Adam will talk about the seller mechanics on that and what you need to look out for to prevent the deal from falling through.
Sure, and you know, to be clear, I'm not going to go into the disclosure obligations of the seller or of the agents in this webinar. We actually have a webinar where I do spend a lot of time on that on our website if you wanted to go check that out, and that talks about what the disclosure obligations are and how to fulfill them. This is more about looking how disclosures can potentially derail a deal or alternatively keep it on track. Most common these days, I think, is that sellers complete their disclosure documents well before even maybe putting the property on the market, and they're packaged up and sent to potential buyers even before an offer is in, which is great, and it's a great thing to do because the law and the contract provide for a contingency that can arise if the disclosures aren't made or if they're amended at a later date.
Right.
So if as the seller you provide disclosures after the offer has been accepted, it gives rise to a contingency period wherein the buyer can review those disclosures and potentially cancel the deal if he or she wants to cancel the deal. Again, I am of the opinion that disclose, disclose, disclose. So if you've got to amend, if you've got to make a later disclosure, just do it. It's not worth sitting on it. Absolutely. Get it out there. And again, if the buyer decides to cancel, that's obviously not the best thing for you. You've got to go back to the market. But then again, you do not want to sell a property to somebody who is going to find that out later on, which they will. It always happens. And doesn't want it because of that reason. You don't want that deal. Even though, you know, nobody wants to go back to market, it's more important to be thorough. But from a standpoint of saving the deal, you know, make sure you're as thorough as you possibly can be at the outset. Don't sit on anything. Don't wait till later. Because if you do, it can give rise to that contingency and allow the buyer to back out.
Agreed. And as the buyer, as I mentioned before, make sure you review all the disclosures because by law, if you receive them, you've deemed having reviewed them. And so, you know, don't skip over pages in the inspection report. Look through them. And if you have any questions, ask. But you're going to be held to those documents that you received, and down the line, if you bring a lawsuit for non-disclosure against the seller, which really it's really not beneficial to anyone. Lawsuits are very tiresome, but sometimes they do happen. And if you need to bring suit against the seller for non-disclosure, you know, anything that you received prior to making an offer or during the transaction, they're going to hold you to that. And so make sure you review them and ask questions when you have them. And also, back to my prior point, if you see something in the inspection reports that you don't like or you don't want to deal with, that doesn't necessarily end the transaction. Talk to the sellers, talk to the seller's agent, ask them if there's anything that we can negotiate to either have them fix it or reduce the price, something along those lines to make it still, you know, complete the sale, but you're not going to be dissatisfied later on.
Right. And just to dovetail on that, you know, a quick point to the real estate professionals who may be listening to this webinar, you know, and especially if you're on the buyer side, you know, look at those materials that you're getting from the seller and make sure that your buyer understands them, right? Make sure your buyer has read them and that there's no questions. If there's flags in inspection reports, draw those to your buyer's attention. It's part of your obligation, in my opinion, as an agent to do that. And it's going to create for happier, you know, buyers and happier sellers at the end of the day. You don't want to be dealing with these things after the fact in the form of a lawsuit or mediation or otherwise. So just go through it. You know, it's simple to do, and your buyer will appreciate it, and ultimately, hopefully, that would bring you more business at the end of the day. You know.
Yeah, and I think that just an important note to make is that agents have a fiduciary duty to their clients, and while it might not be statutorily required in the form or something they've learned in a class, you owe your client the highest duty, and arguably that could mean pointing things out about the property that the buyer would find material. And if you really want to try to protect yourself, every agent tries to avoid lawsuits. It's not fun, and insurance has to get involved, and it could really be just a stressful experience. If you want to try to avoid that, just go above and beyond and meet that fiduciary duty, and then a lot of times that could prevent a lot of disputes.
Yeah, just a little, not to plug again the webinar and disclosures, but we do cover that in that webinar that's on our website. And this is something that we all here love to speak with agents about. So if any of you out there are interested in diving into this, one of the things we do is go out on site and talk to you and your team or your office, whoever it may be. So feel free to drop us a line if that's something that you might be interested in.
Yeah, we love doing that for sure. Next. That brings us to notices to perform, and this relates to contingency specifically, but more so if a party is lagging. And a lot of times people think that when this is served, it's kind of you're declaring war. And it really, people need to change their mindset about the NBP form. It's the CAR form, notice to buyer to perform, and it just should be a flag or a warning to the other side, hey, release your contingency or do what you're supposed to do. And these forms are very important because, one, it keeps the transaction on track, and also it forces communication. So if you serve the NBP and the other side isn't ready to close, then usually that's the first time you hear about it and the first time that the parties start negotiating to figure out a solution. So say if the buyer hasn't gotten their loan yet, the seller serves the NBP to release a loan contingency, the buyer is going to say, hey, I need 2 more weeks per my lender, can you work with me? And a lot of times the sellers will have no issue doing that, but the form's important, one, because it's legally required, but also because it opens that channel of communication so the parties know what each other needs. And I think you can speak on its... Yeah,
I mean, to the point being that it's legally required or contractually required is that nothing, at least taking the CAR form contract, is self-executing. So in order to exercise those contingencies or waive those contingencies, action must be taken. They aren't satisfied, and they don't lapse by passage of time. You've got to take affirmative steps. And so from the seller's perspective, that's the notice to the buyer to perform, the NBP that Ashley was talking about, and it's got to be served before the buyer has to do anything. This goes back to the example I was using earlier about putting 0 in that CAR form for the contingency period. Well, why is that not effective to make it not a contingency? It's not effective because the contingency itself never expires on its own.
Right.
That period, if we're going to state it most accurately, that period controls when a seller can serve a notice to perform. It does not control when the contingency expires. The contingency only expires when the seller serves that notice, and then there's usually a 2-day period. Parties can change that, but it's typically a 2 or and then there's another similar form, command and close escrow, which I think is a 3-day period. But in any event, that's what that time period is all about, and you can, as the seller, can serve it as close to as 2 days before the expiry of that period. So if we take the default, which I think is 17 days, that would mean that as the seller, you could, as a matter of course, serve it on day 15, and that would give the parties their full 17 days to either waive that contingency or cancel the deal. It's typically not done. I don't personally, as a lawyer, know why. I have some understanding why I think real estate professionals don't do it. It's, I think, often seen as sort of
declare,
like it comes with animus or something that we're trying to cancel the deal. I really don't see it that way, although I do understand why others may see it that way. But I really think that a best practice would be to just always sort of say, hey, I serve these things as a matter of course. I'm serving this to you now. I know you've got 2 days left. If you need extra time, reach out to me. I'll talk with my seller. I'll talk with my buyer. Whatever it is, you can kind of buffer it with that. But the reason why is I've had sellers come to me who had wanted to cancel deals and couldn't because their agent had not taken that step of serving that notice to buyer to perform or advised them accordingly about that notice. And then they were surprised when they asked to cancel when they thought the contingencies had quote-unquote expired or lapsed, and they really hadn't because no notice had gone out. And so the sellers were obviously very upset about that and kind of took issue with that. I'm not saying that there was necessarily any liability on anybody's part, but you know, again, that's what the contract says. That's how it works. So that's what you should do, or at least be upfront in your communications with your client or the other side about what it is that you're doing.
And arguably, if you don't serve it until that 17th day, your client is 2 days late in serving it, and and if you know your client is in a hurry, and if this buyer doesn't perform, wants to move on, that could really cause problems for you. Have you ever seen anyone not serve the NBP, and what was the result of that?
So we have seen that in practice, and the result was that there was a serious dispute about whether or not the contract remained in force. And so, you know, again, it's there are, you know, as with all things legal, there's always an argument and that can be made, and the facts are always more complicated. But I mean, it's a very easy way to end that argument is to get that form out, because certainly not serving that form creates a lot of ambiguity, which then can create a really expensive mess.
Not fun for anyone. And that brings us, you want to talk about specifically this in versus out of contract verbiage used by so many agents, so many clients we have calling and saying, you know, am I out of contract or am I in contract? And you could speak to that. And I think it's a little bit of a pet peeve of yours.
It is. I think that the language is very much imprecise. It does not, in my opinion, describe accurately the legal relationship between the parties of the contract, and yet it's commonly tossed around as a meaningful descriptor of where parties stand in the course of a deal. And so let's break it down. My general understanding of usage of this language by a lot of real estate professionals is that in contract means that all the dates and deadlines in the CAR form, which are many, have been complied with up to that point. And specifically, it's usually used in reference to, you know, loan contingencies or appraisal contingencies or inspection contingencies. So let's just take the inspection contingency, right? I mean, if they've, you know, waived timely that contingency before the 17 days by default, for example, agents will say, well, we're in contract still, we're in contract. Whereas if you pass that 17 days, and nobody has waived that contingency, well, you know, they're out of contract. Or the financing contingency, maybe the loan's taking longer than they had thought, and they go beyond that period, which I think is 21 days by default. You know, agents say, well, you know, they're working on their loan. Technically, they're out of contract. No, technically, they're not in or out of anything. If there's been no notice to perform served, the buyer is in the exact same position that the buyer was in at the time the buyer sign that contract. Arguably, the only distinction is that now the seller, because of the passage of time, has the ability to serve a notice to perform. But again, the seller's got no right to cancel that deal at that point in time, arguably, and you know, that step needs to be taken. So telling your clients that you're out of contract, I think, to the layperson can be quite misleading, because if I hear as a layperson that I'm out of contract, well, that means I'm not in the contract anymore, and that's absolutely not the case. The contract has to be canceled, and so part of that is the notice to perform, and the buyer could waive. The buyer could risk the deposit and waive that contingency and say, you know what, I know that I'm not done with my inspections, or I don't have my loan guaranteed, but I'm willing to gamble my deposit, and so I'm going to waive that and hopefully close escrow on time. People have done crazier things. It's not any different really than making a non-contingent offer. So, you know, it's especially with respect to the listing agent and the seller, it can be very misleading to tell your client you're in or out of contract, because it's really not a legal term at all.
And one of the most dangerous things I think I've seen happen, and that could happen for any of you out there, is you either tell your seller, or you're the seller and your agent tells you you're out of contract, and then you go and get in contract with another subsequent buyer, and then you have two ongoing contracts, which is almost inevitably going to end up in court. And you know, you're going to have a very unhappy client. If you're the seller, you're going to be very unhappy when you get told that you're going to be sued by one of the buyers and be forced to sell to one of them, and you know, 50, 100 grand later in attorney's fees, someone's going to be liable for that. And I think that is one of the bigger issues with being out of contract or thinking you are,
Mhm.
and you're not, and you go and you get into another transaction, and then it's just a total just mess.
Right, right. Yeah, that's why I personally disfavor the terms. I think they're fraught with risk, and they just simply don't accurately describe the way the contract functions.
Right. So next, we just want to go over some common disputes and solutions to those disputes that we see come up all the time. First, as we discussed, issues discovered during the contingency period. And the main solution I find for this is, again, negotiating and communicating. Cancellation is not always the best option for either side, and a lot of things can be mitigated either through an agreement to repair or a reduction in price, because ultimately it comes down to money. And if you find a crack in the roof or foundation, and you don't want to pay for that as the buyer, totally understandable. The seller might be able to give you a $10,000 discount for the roof, and then you can go and fix it after you close. And that's really common, and people just panic when they find a problem, and I don't think that's the best answer. And agents need to be able to tell their buyers, look, we don't have to cancel yet. Let's try to work with the seller. And the seller's going to know that they have issues moving forward, because now that the problem has been discovered, they're going to have to disclose that to new buyers, so they're going to have to deal with it no matter what. So they might as well deal with it with someone that's already in contract, that's already committed, and just get it done, because they're going to have that same issue moving forward. Also, I've seen a lot, especially in the market, how much people are putting in for deposits and getting loans for a change of heart. And they get real excited about a property, and one thing leads to another, and they start to doubt it, or they don't want to spend that much money, or whatever the case may be. In this instance, cancellation might be a good solution, and the sellers are sometimes willing to agree to that, just because if the market's gone up, they can get a better offer. They're not going to have a dissatisfied buyer. So again, you need to communicate. And the number one thing I see happening is buyers don't tell their agent, and so no one knows, and they close escrow because they think they're contractually obligated to do so, which you are, but you need to communicate your dissatisfaction right away, because, again, things can be worked out. The deal can be canceled if both parties agree, and there might be a solution that just by voicing your concern right away, you might have a way out, and I think it's very important to start that communication early. Also, more importantly, just a practice for agents that represent buyers and buyers for you to know is to make sure your agent knows what you want and need before you even start looking for a property. If you want to be in a good school district, if you want a pool, if you want to be in a mountain region, that type of thing, make sure your agent knows. That way the properties you are shown match your needs, and you don't get into a situation where the agent didn't really know what you were looking for.
Right. Yeah, and again, it's all about this is not within the scope of the Save the Deal webinar, but if you are a buyer, you are looking to cancel, we've helped a lot of buyers do that. There are lots of ways to make that happen in a manner that's reasonably satisfactory to the buyer and the seller. And so there are ways to do it. Don't just pull the ripcord. A little bit of planning again can mitigate the damage to everybody.
I agree. And then we have two more we've talked about a little bit. Not enough time on either side, but it's more commonly the buyers that run up against these deadlines or the close of escrow, and they haven't finished what they need to do. Again, use amendments, even addendums too, depending on what is causing the delay. And communication. Let everyone know what your lender's saying. If your inspector isn't available, let everyone know. It's just a matter of having that open flow of struggles and delay throughout the transaction, because it's totally normal. Say if you're buying a property right now during the holidays, people are busy, people are out of town, things get delayed. If it's raining and that's stalling the inspection, communicate that. Communicate your concerns, and usually there's a solution. One of the bigger issues I see that people don't really anticipate to be a problem are when there's tenants in the property.
Right.
And it could go multiple ways. So first, if you have a tenant in there in a single-family home that might not necessarily be subject to rent control or those types of issues, they don't cooperate with showings or inspections.
Mm-hmm.
And there's this relationship with the tenant and the seller that's contentious, and they're mad that the seller is selling the property. They're going to have a new landlord, or they might get evicted, and they don't want to cooperate with anyone entering their home. And buyers need to be mindful of that, and also agents, that if there's a tenant in the property, that's where someone lives,
right.
and you need to be courteous. And there's certain notices to serve, which I've written an article about. You can find on our website. It's called Selling a Property with a Tenant. Mm-hmm. Like specific guidelines that require both sides to do things. But I think just being mindful that someone lives there and respect their space, that could be the number one way to avoid their lack of cooperation. And also, if you're buying a property that is in rent control areas and is subject to those controls, mm-hmm. you need to know before you even make an offer if that's something you want right. to deal with. And your agent needs to know what you want to do with the property, because we've seen people make an offer, mm-hmm. be in the transaction, and then realize they're not going to be able to raise the rent or get the tenants out,
right?
And they want out, and it's
right.
too late. And
yeah, we've seen actual transactions
yeah.
where the seller bought
yeah.
on the premise,
yeah.
or I should say offered to buy on the premise, that they assumed that they could, do as people often do, which is buy a property,
yeah.
kind of update it, up the rents, maybe get new tenants in there. All reasonable assumptions on some level,
sure.
but in a rent-controlled jurisdiction, the odds of that happening are slim to none, because there's controls right. in place to prevent exactly that. And so, if you've got a buyer who is an investment buyer, for example, who's yeah. going to be looking at doing that, and you're not flagging that for them, that's a problem, and it can lead to, again, the deal not going forward.
Right. So planning ahead in this instance would help,
would have cured
quote,
that.
unquote, save the deal, or
right.
prevent it from even being an issue in the first place.
Exactly.
Next, we're going to talk about closing and finance issues. In the next two slides, Adam's going to talk to you about loan complications and title issues first, and I think these are big ones and something people need to be mindful of.
Right. So with respect to loan complications, I'll rewind to, making the deal itself. I think this is an area that's sometimes overlooked, mm-hmm. and it can cause deals to fail if not addressed at the time the offer is made and the contract is formed, which is that the loan terms that are in the offer
right.
Are part of the contract, right? So if you've made a contract and it includes certain terms as far as, cash in, loan balance, interest rate, and importantly as well, what type of financing, conventional, yeah. FHA, VA, those are terms of the contract. And so if you write a contract based on conventional financing and then switch to FHA financing, for example, that arguably could be a breach of the contract, or a potential breach of the contract that could cause the deal to fail, either because the seller doesn't want to deal with that,
right.
because as most professionals know, FHA financing, for example, can be more complicated
oh, yeah.
than conventional financing. That's going to cause a problem. So you need to nail that down, and then also from the perspective of the buyer or the agent for the buyer, you want to make sure that those are accurate, because you don't want to, again, cause unnecessary problems for your buyer, cause a problem where the buyer could potentially lose the deal because of a change in financing,
right.
Or alternatively, prevent your buyer from getting out of the deal if the financing terms can't be met. So if you're writing in there financing terms that are too ample, or an interest rate, for example, that's too high,
that
right?
They can't achieve,
and they're able to achieve an interest rate, but it's undesirable. But because you've put a high rate in the contract,
yeah.
now you've arguably, don't have the right to exercise that loan contingency or that appraisal contingency. Now, obviously, it's more complicated than that,
yeah.
but those are just things to think about. You don't want to play with those numbers unnecessarily,
right.
or kind of fudge those numbers as a way to make the deal more attractive to the seller, because
yeah.
you rob your buyer of the opportunity to potentially cancel the deal if that's what needs to happen.
Right.
Title issues, sometimes those can be hard to anticipate. 2 points on that. Number one, back to the overarching theme of go in prepared. Look at the title report early on. Most people open up an escrow at the same time that they start preparing the listing.
Yep.
So get that report early, get it out to buyers early. On the selling side, review that part of the review that disclosure early and identify any issues. We've had deals go where parties have executed a contract, they're in the deal, and it comes out that there's mechanics liens affecting the property or other, what I would call basic liens affecting the property that really could have been cleared up easily before listing, or the listing could have been up front and said, hey, we know there's a couple mechanics liens, we're going to take care of those before escrow closes, so on and so forth.
Or an addendum.
Right, or an addendum, right?
Yeah.
And nobody deals with it because either nobody looked to spot those issues, which is the most common cause, or people just didn't think that they would need to be addressed.
Right.
And we've been able to easily clear those up and get deals closed all the time with those types of liens. So they're usually not that hard to take care of. But again, it's something that you've got to deal with.
Right.
And the deal won't close without it. You will lose the deal if you don't deal with that, because your title company is not going to, issue an insurance policy. They're not going to let the deal close. Your lender's not going to close with those things floating around out there. So it's definitely something you got to address. And if it does come up, in the transaction, call an attorney, us preferably, that'd be nice. But any competent real estate attorney, and get them involved quickly, because they can dispose of those usually a lot faster than other people can by implementing the right procedures.
Right, and we have a lot of good relationships with title companies in the area, all over, and we've established those relationships and can call them and on the drop of a dime and get through. So we're a good resource for that, just with title companies, because we've established that relationship and they trust us and we trust them. And if you need help with title, we do have that relationship established. Also, costs. I have a lot of agent friends that really try to advise their clients of this. The loan and the deposit are not the only things you need to account for when you're budgeting to buy a property. There's other expenses and fees that come up in closing that can really blindside a buyer, and you just need to budget from that and have a little bit of excess in your budget on top of the what you anticipate to pay with your deposit or anything else for unexpected costs, because it's almost inevitable in a transaction. So really plan for that. We see that come up where buyers get super dissatisfied with having to fork up another 10 grand for a transfer fee or something along those lines that isn't exposed until they get ready to close.
Right.
Next, I want to talk about natural disasters. And, this can include fire, flood, hurricane, not necessarily in our area, more earthquake it would be common. Just for instance, on the PRDS form, they address this specifically. They say that the buyer has a right to cancel if it happens before close of escrow. And the CAR form just cites the Civil Code section 1662, which they both say essentially the same thing. It's just odd how one cites the code and one actually says the buyer's rights. If any of these things happen, typically the buyer has a right to cancel as long as title hasn't transferred and you haven't closed. So if there is an event that happens, or there's a fire or something that damages the property, you have a right to cancel as a buyer more than likely. And don't sit on it. Don't go ahead and close escrow, because it's going to be too late. You need to act before you close and before you get title, because if you do close and you are the owner of the property at that point, it may be too late to reverse. So that's something to look out for that can come up close to closing, really anytime during the transaction. And as a buyer, you need to know your rights for that. Also, repairs, as we've talked about multiple times, don't be afraid to ask the seller for either to have them do it or to give you money to do it out of the purchase price. Just ask. That's our really number one advice on that.
I think this is a pretty big misconception, or at least misunderstanding on the part of most buyers, most sellers. Almost every contract for sale of real property in California, especially those using the CAR form, of course, is an as-is sale, right? So you're taking the property as is. But that doesn't mean two things, right? It doesn't mean you don't have to make disclosures, right? Again, see the webinar on that point. And it doesn't mean that you can't negotiate based on what you find about the property, as far as potential defects or otherwise, right? The seller, of course, can say no. But then again, if something is new and that discovered that the seller didn't know about before, now the seller's going to have to deal with that with any subsequent buyer, because that's a disclosure issue.
Right.
So as is doesn't mean that you can't ask for changes. So the seller should be under that understanding, not be offended if the buyer asks for any changes.
Yeah.
Know their disclosure obligation. And from the buyer standpoint, if you want something, ask for it.
Right. And before we get to questions, and just as a note, if you do have questions about what we've talked about, start sending those to Clayton now. He's running this webinar and he's going to forward them to us. But we want to go over one program that we've established that's actually in its inception, and Adam can talk about that. Can you tell them about our Assist program?
Sure, yeah, this is the shameless plug alert. So we deal with these sort of midstream disputes in transactions all the time. And the great part about it is that, in my experience, and I think Ashley's had the same experience, when you bring a lawyer into the deal, when the ship is starting to sink, we can quite often put it back on track and get the deal closed. And there seems to be sometimes a stigma out there that lawyers are deal killers. I have never found that to be the case. Most of my clients want to get the deal done, either from the seller side or the buyer side. There's almost always a middle ground that can be achieved. And then there's also almost some technical stuff we can do, like to use the liens, for example. I mean, we've had clients who were sitting on properties that were affected by liens for over a year before they came in to visit a lawyer because it just wasn't going anywhere.
Yeah.
And we were able to get those liens cleared up in a matter of months and get the deal closed.
Right.
And so, it's incredibly valuable. And because we work with a lot of real estate professionals, both directly and by referral, we came up with this Transaction Assist program where we are extending that if you come to us in the middle of a deal to try to work something out, we can extend a discount of 15% on the first 15 hours of our work. And we've come up with that number because we've learned through experience that's usually enough time for us to take the deal from near failure to, successful completion in some fashion. So it's just a way that we like to invite you to bring us in early because we think we can be more effective. You're going to be happier if you come to us after close or after the deal's gone, south. It's going to be too late.
Way more
expensive. It's going to be way more expensive. You're going to be less happy with the result. So we like people to see us early on. This is a way that we're trying to see if we can incentivize people to reach out when we can be of the best help to you.
Yeah, I mean, as much as we like litigation and everything that comes with that, we really don't want to see our clients in that if they can avoid it. And this is just a program to help you avoid the court. No one likes being in a deposition. No one likes being on the stand. And so, let us try to help you avoid that and jump in when it's actually hot and get it figured out and just act as your advocate, but not necessarily a contentious one. We like to consider all our attorneys pretty reasonable, and we represent a lot of just people, not necessarily corporations, people with a huge budget for legal expenses, and so we really understand that it can hurt to have to pay legal fees, and this is just a way to try to help that.
Right. Yeah, we like to think of this as the bat signal for real estate transactions, right? If things are going down, you throw up the bat signal, we come in and we do what we can to help you out.
I like that. So with that, now we're going to get to questions, and we have one already. The first one we're going to answer is, what is the difference between an amendment and an addendum? If you want to speak to that, you just...
Well, I mean, the flip answer would be the difference is, the word addenda or the word amendment. If you want to get technical about it, I think that the better answer is that an amendment is something that changes an existing contractual term, whereas an addenda adds a term to the contract that wasn't there before. So that, I think, would be the technical difference. Functionally, I would think that from a practical standpoint, there's probably not a huge difference other than describing what you're doing. Are you changing something that's already in there, or are you adding a new term? Either way, from a mirror image standpoint, to tie it back to the beginning of the webinar,
Yeah.
It creates a mirror image problem, whether it's an alteration or an addition,
Yeah.
or subtraction for that matter. It's going to create the same issue. But the overarching point is to use a separate form to accomplish those objectives.
Right.
You know, if it's an amendment, again, referring back to what you're amending. Hey, we're changing paragraph 2 to read as follows.
Yeah.
Or you know, if it's an addendum and you're adding a term to the contract, then you know, spell out that term expressly in there.
Right.
And it's just a way of having a clear contract versus trying to write on the same form or check different boxes or scratch things out.
There's no room.
Yeah, it just creates ambiguity.
Yeah, I just think amendment is a change to the contract and addendum is to add.
Right.
That's the way I separate it out, just depending on what the parties want to do.
Mm-hmm.
Next question. Ooh, this is a good one and something that we're dealing with right now. Which disclosures are required for vacant land sales? And we actually have a case on this.
Yeah, I mean, that's, I would say, outside of the scope of our Save the Deal webinar. Certainly, the answer I'm going to have to give, and actually it's going to laugh because I say this all the time,
Yep.
Is the lawyerly answer, which is it depends.
Right.
And it depends on what the parties' agreement says and otherwise. I will say that, you know, under the civil code, the disclosures required in a typical residential sale are very different than those required in a vacant land sale. In fact, the ones required in a vacant land sale can be incredibly limited or zero.
Yeah.
So, you know, you've got to, you know, look at your contract carefully and review that carefully. So I'll say it's definitely different than residential sales.
Sure. Next one. Is there a point where too many amendments or addenda require a brand new contract or start over? Question mark. I think that that's twofold. First of all, should you start over potentially? And I think that may be a good idea for clarity's sake. But I don't know how you feel about this. I mean, I've seen as many as 3 or 4 of each, and it's really a matter of being organized by the agent and keeping them in line and labeled and make sure everyone signs them. But have you ever seen where people have executed a new contract just because it's gotten too convoluted? Yeah,
I have, and sometimes I certainly would advise doing that if everyone's amenable to doing that. You know, one of the things that you have when you have a lot of offer, counteroffer, you can miss terms, and this is the problem that you have that I think the question's probably referring to, is, you know, if you've got a counteroffer and it says, okay, you know, I'll accept your offer, but only if you change the purchase price to this amount and then add the following terms. So you've got an amendment and an addendum essentially in one counteroffer, and then you have another counter to that counteroffer that, you know, maybe strikes out one of those addenda and again amends the purchase price. So you've got yet another amendment and another addenda, and now you're really sort of potentially getting fuzzy as to what is still included in the deal, what is not included in the deal. So at some point it may make sense to sort of just, even if you're not making a whole new contract, but just sort of making one final counteroffer that says, okay, these are all the terms, and none of the other terms in the prior, you know, counteroffers is included in this deal, or something along those lines, and that clarifies and it kind of crystallizes what is included in the deal and not included in the deal. It's really about clarity at the end of the day. It's, you know, legally speaking, it's not necessarily a legal issue. It can cause legal issues, but it's really an issue of clarity and adequately recording what the parties understand the terms of the deal to be.
Yeah, and if we think about it from a lawyer standpoint, I think we're in a lawsuit here, and we have a contract and 4 addendums and amendment. I mean, that's going to be a complicated case to litigate, and no one wants to think that way, but I think from our endpoint, if we could give advice on that, is one contract alone is much more easily understandable than a contract and 6 additional documents, and things get lost in the shuffle. And as you said, lack of clarity is a big thing, and that's not something you want in a dispute regarding a contract, because that can really vary what ends up being the result of a dispute. And so I think just if you think long term of where, you know, your documents can end up, if you draft everything with precision and the idea that it could one day end up in front of a judge, I think that would be a good answer, because you don't want to give them 7 different documents to try to understand what the parties agreed to. And so I think that goes to your point even more. And I think that is all the questions we have. If you have any more, feel free to send them on our website, email us directly, and we'll be happy to help you. And thank you for attending. And everyone have a wonderful holiday season, and hopefully you get some time off to spend with your family.
Yeah, thanks for tuning in, and hope to see you the next time.
Thank you.